Hi everyone, it's James from Community Legal Centres Queensland. Welcome to another one of our webinars. I'll begin this session by acknowledging the traditional owners of the lands on which we're meeting through the miracles of modern technology. I'm south of the Brisbane River here, so I acknowledge the Yagara people as the traditional custodians of this land. And Caris, traditional custodians in your part of the world?
Sorry, James, that's a really good question. I was familiar with them down in Albany, but not so much up here.
Oh, sorry to put you on the spot. Can I acknowledge traditional owners everywhere, because we do have people joining us from across the country. So acknowledge First Australians, acknowledge elders, ancestors, any Aboriginal and Torres Strait Islander people who might be joining us today, particularly as today is the day that the Redfern Statement's been presented to the Prime Minister, which is a really important development, we hope, in the way in which Aboriginal and Torres Strait Islander people can work with governments and communities across the country. Really pleased to be presenting a webinar on property settlements. Caris Tysoe from Peel Community Legal Services will be presenting that. Before she does, a couple of housekeeping things. We're hoping to have a recording of this webinar made available to you, and we'll email a link to that if the technology lets that work. Can I also let practitioners from Western Australia know that because you have a more formalised system of treating your continuing professional development, that this session has been approved, and you can contact the Community Legal Centres Association of WA if you need a certificate to report that to your regulator. For most of us in other parts of the country, though, if this is appropriate to your legal practice, then you can treat this, claim CPD points in accordance with the rules in your state or territory. Also emailed around a copy of Caris's PowerPoint to most of you a couple of hours ago. You can also access that from the handout section of the GoToWebinar control panel there, and otherwise the link's available on our website too. Couple of ways that you can ask questions as Caris is talking. One is to type a question into the questions box on your control panel. The other is to press that button that looks like a hand on the control panel. We'll see something that looks like a hand go up at our end. We'll be able to unmute your microphone and you'll be able to ask a question that way. I know Caris has got a few disclaimers through her presentation. Can I, at the outset though, recognise that the family law system and the family law courts in Western Australia are very different to other parts of the country in the way that they operate. So Caris's presentation focuses on the way that the West Australian family courts work. It's a fascinating model, and one that certainly was given consideration here in Queensland as part of the Not Now, Not Ever task force report into family violence, because I think it's, generally speaking, a pretty good model that brings together what are in other parts of the country, including here in Queensland, are quite disparate and disconnected at times aspects of family law and family violence systems. So it's a really interesting model, but please do bear in mind that the information that's being provided today in some part is particular to what's happening in WA. But I know Caris has a whole heap of further information that she'll go into there. So can I hand over to Caris, a lawyer from Peel Community Legal Services, to talk to us about property settlements. Thanks, Caris.
Thanks, James, and thanks for making that note as well. Okay, yeah, so thank you for the introduction. So my name is Caris, and I'm a lawyer at Peel Community Legal Services, which is located in the Peel region of Western Australia. So on to the disclaimer. So today's presentation has been developed from the community legal education that we deliver on property settlements. I've tried to make the subject matter more advanced to suit the legal audience today, but at the end of the day it's still an introduction, and I'm not a specialist in the area of property law, and it is a very specialised area. What we'll be covering today is the first half of topics. Before I go through them, I've tried running through it to get an idea of how long it'll take me to cover this content, and I'm hoping that I'll manage to get through it all today, but there might be a bit of overflow from today's session into the one that's on tomorrow. So James, sorry, but if I go over time or I'm hitting the time limit, just let me know. So what we're covering today is what's included in property, the who and when of property settlements, how the Family Court of Western Australia will treat property settlements, the four-step process that's involved, marriage and de facto relationships and some differences between them, a practical example of how that four-step process actually looks in reality, and then we'll go through some more sort of particular areas like superannuation, which is particularly important for anyone listening from interstate, short relationships and sort of the impact of those, loans and gifts, and spousal maintenance. So I've started off with just a note on the relevant law because, like James was saying, I'm in Western Australia, and unlike the other states, Western Australia elected to establish a state family court rather than referring its power to the Commonwealth. So the state court that we have over here has been vested with federal jurisdiction so that it has jurisdiction in matrimonial matters as if it was the Family Court of Australia. And that means that the applicable provisions for us for separated couples in WA who have been married are found in the Family Law Act, that Commonwealth Act. However, the provisions relating to de facto property settlements are found in the Family Court Act, which is a Western Australian piece of legislation. Because of this, practitioners need to be conscious of not only the Family Law Act but also the Family Court Act because they can both affect our clients. A lot of the provisions are the same between the two or substantially similar, but they appear in different sections between the two acts, so it can be difficult to directly compare them, and some of them are very different. And the most notable of those is superannuation, which, as I said, we'll be looking at a bit later today. So to start, what's included in property? As you might expect, it's quite inclusive. We listed a few of the main points here. Some of the time clients don't expect that some of these will be included, but it does include jointly owned assets, property owned in the name of one party only, superannuation if the couples have been married, and again we'll be looking at super later, business interests, an interest in a company, family trusts as well as other trust interests, funds or interests over which a party has influence or control, assets owned prior to the commencement of the relationship, assets acquired during the relationship, and assets acquired after separation. So it'll include your standard stuff like houses, cars, bikes, boats, jet skis, the household contents, bank accounts, shares, managed funds, investments, life insurance, collectibles, money that's owed to one or both parties, any asset having a value as well, so things like frequent flyer points, unused annual or long service leave, or overseas assets can also be included. So it's really quite broad. And one thing that I wanted to note here as well, particularly with all of us working with clients, is debt is included as property under both acts. So when you're getting instructions from your client, it's really important to make sure that your client understands debt that's only in their name or only in the other party's name can be included. A lot of clients have this idea that it's only joint debts, and that's not the case. So you don't want to give them any unfortunate surprises down the road. On to who can seek a property settlement. Couples can apply for a property settlement if they've been married or in a de facto relationship, although further requirements are going to apply in the case of de facto relationships. And I mean that in addition to actually indicating that it was a de facto relationship. So in addition to showing that it was a de facto relationship with those factors like how long the relationship lasted, whether they lived together and that sort of thing, you also need to look at these requirements. So for a property settlement for de factos, the relationship must have lasted more than 2 years, or there must be a child less than 18, and without a property settlement there would be serious injustice to the partner caring for or responsible for the child. Those are the certain circumstances on the slide there. Or one partner has made substantial contributions, and without a property settlement there would be serious injustice. So that's an or, so satisfying one of those will get you over the bar. In addition to those, we've then got jurisdictional requirements for de facto relationships, because if you want to obtain orders from the Family Court of WA, the court wants to know that it's actually, within jurisdiction and relates to Western Australia. So that's them there. You need to have separated on or after 1st of December 2002, and that's sort of related to legislation that was passed on that date. One of the parties has to be living in WA on the day of the application for orders, and the two down the bottom there are or, so either both parties resided in WA for at least 1/3 of the de facto relationship, or substantial contributions, and we'll look at contributions in a minute, but they can be financial, non-financial, or homemaker or parent contributions, were made by either partner in WA. And the when of seeking a property settlement, clients can seek a property settlement as soon as the relationship has finally broken down. There's no waiting period that applies, and if they're married, they don't have to wait for a divorce first. But there are time limits that apply. Parties can't commence proceedings for a property settlement more than 12 months after a divorce order for married couples, and not more than 2 years after separation for former de facto couples. However, the court does have discretion in certain circumstances to allow property proceedings to commence beyond those limitation dates if the court is satisfied that there will be hardship to a party or to a child if that leave is not granted. When they're looking at that, they can look at several factors, which were looked at in the case of Richardson in 2008, and that includes the length of delay, the reason for the delay, any prejudice to the respondent due to the delay, the strength of the applicant's case, and the degree of hardship. But of course, as we all know, it's much better not to rely upon getting leave out of time and to just make that application within the time period. So in practice, a lot of clients that I've seen, they approach separation from a marriage wanting a divorce first. For some of them, that's because they think the divorce will deal with the property, which it doesn't. For others, they think that that's just the order that it has to be done in, which is also, incorrect. Like I said, there's no waiting period. So sometimes advice on that can be really helpful because the client will realize that they can start sorting out those property issues within that pre-divorce 12-month separation period, which can, be quite different compared to waiting until afterwards, and then they're avoiding that possible issue with the time limitation post-divorce. So now, the applicable laws there again, and the approach for Western Australia, the court's applying a 4-step process to determine how the property should be split. Any lawyers that have experience in the area are probably going to know this sort of 4-step process pretty well, but I'm going to be running through it today step by step anyway. So we've got an overview of the 4-step process here. Like I said, we're going through each of the steps in more detail in a moment, but we've got step 1, which is to look at the current asset pool. What are the assets and liabilities that the parties have? And then step 2 is looking at the contributions of each party. So that can be the section 79 4A to C for the Family Law Act, and then they come to an idea of a percentage split. Step 3 is the extra matters for consideration, which is the future needs of the parties, the factors that you can find in section 75(2) and 79 of the Family Law Act. And then the percentage split is adjusted in response to those factors. And step 4 is sort of the final check, just making sure that the final split is just and equitable, and if you're in court, that any of the orders that are being made are just and equitable. One thing to note here is that although this is what the law says and the way that the court works through property settlements, it can also be really useful to inform negotiations and out-of-court settlements. So even if your client isn't planning to take their property settlement anywhere near the court, it can still be really helpful to advise them of this process. So the first step that we've got is to identify and value the current assets and liabilities of both parties. This is done by getting the total value of assets and subtracting the total liabilities to end up with the net asset pool. And as you can see down there again, it's the assets and liabilities in the joint and the sole names. So a common misconception among clients is that the debt or even an asset in one party's name isn't going to be included in that pool. So it's really important to be careful with how you're asking for those instructions, especially in the early stages. Otherwise, you might miss a house or a car in the other party's name or a credit card debt in the client's name, and that can have a really considerable effect upon your advice, especially if the clients come to see you about potentially reaching an agreement with the other party. For working out the values of the assets, there's no hard and fast rules about how clients should value things. A lot of the time it's a case of the parties coming to an agreement about the value. If a value can't be agreed upon for an asset, then generally it's going to need to be valued by someone who's independent and qualified to do so. So a certified valuer or an expert, and that can often be quite expensive. So ideally, having the parties reach some agreement is best. Some suggestions of methods for the parties to use to discuss values and to reach agreement are for houses to ask 3 or more real estate agents for a valuation of what the house would actually sell for, and then to take an average of those estimates. For vehicles, parties can look at Red Book and local advertisements. For tools and miscellaneous items, again, local advertisements can be helpful. For household goods, it's either what they will be sold for, or sometimes parties can agree that it'll be what one party will have to spend to set themselves up in a new residence. Generally speaking, it's, what they would be sold for. Contrary to what some clients think, it's not the value that the items are insured for. Some private lawyers refer to this as being approximately $10,000, and I think for a lot of our clients, it's probably an overestimate of the household goods, or at least for a lot of the clients I've seen. Valuing bank accounts, you can just get a printout of the current balances, and valuing super, again, we're looking at super in more detail later, and I keep saying that, it's because it's a very specialised area of property settlements. But for super, you can pay for a proper valuation, and sometimes that's a really good idea because it is possible to misrepresent super value on some funds. Another thing to bear in mind when working out the values of the assets is that the values are assessed at the date of trial, if the matter reaches trial. And we've got financial disclosure there. That's just a quick note at this point. I do look at financial disclosure in more detail later. But basically the parties in this sort of proceedings are required to provide financial disclosure, including their assets and their liabilities. And this is really important here in step 1 because obviously to get an idea of what's in the asset pool, you need to know what both parties have. And if the other party, if you don't know what they've got, all you're able to analyse is what your client has, which is not really very helpful. And then I've got add-backs there as well. Add-backs can be sort of a more complex area. It's basically the idea that an asset that no longer exists or is no longer, I guess, in the possession of the parties may still be included in the asset pool as an add-back. Examples of those can include wastage, so people's gambling addictions, premature disposal of assets, for example, selling a house early on in the, before you've reached the property settlement, and sometimes legal fees as well. Add-backs aren't a given and they can go either way. Jacoba Brush gave a webinar last year which was about property settlements, and that was really helpful, and she did note there that it wasn't entirely consistent. Sometimes things were added back in some cases but not in others, so it's just not a consistent sort of rule that you can apply. I think part of that is that the court usually views property settlements as the division of the current asset pool, and part of the nature of add-backs is that they're not actually in the current pool anymore. They no longer sort of exist in reality. That money has been given away. It's not there anymore, that sort of thing. So instead they're notional assets, so they're not actually there. Following the case of Stanford, there's less actual adding back to the asset pool here in step 1, and there's more consideration of those sorts of issues as notional assets, like I said, in steps 2 and 3, and we'll look at steps 2 and 3 in a moment. But ultimately, really, the potential result for is it going to get added back, is it not, it's going to depend upon what it was and what the reasons were for it. Generally, money that's reasonably disposed of by a party in their post-separation life shouldn't be added back. So if money was taken out of a joint account and was used for reasonable living expenses, that reduces the risk that it's going to be added back. Having said that, clients should be careful if they're doing this, that it's only used for the reasonable living expenses and it's not extravagant. Having evidence to support that is a really good idea as well. Jacoba suggested putting any money into a separate account so that it's visible on that statement that it was only used for reasonable expenses, and I think that can be a really good idea if you're getting involved early enough to give that advice. This can affect clients that I've seen quite often. We see a lot of clients who've experienced family and domestic violence from their ex-partner. It's not rare to see a client who has the child or the children living with them in the refuge, trying to find a rental. She has no job because she's been raising the children. She has no benefits because her partner was earning too much for her to qualify for them. And so in the meantime, she's sort of stuck in the middle with no money. And sometimes these clients have access to a joint account and they want to know if they can take some or all of the money. And generally our advice in that sort of situation specifically is to take it. But we also explain to the client that they might need to account for it when the property settlement happens. It's really a case there of weighing up the potential negative that that amount will be added back or taken into consideration at property settlement versus the reality of the now, which is that you've got this client who is really struggling and has no financial resources at all. And when you're looking at that kind of joint account situation as well, you should be considering if there has been family and domestic violence, it's really likely that taking some or all of the money in that joint account is going to set off the other party because it's throwing off that sort of financial control and power imbalance that's in place. So you really want to talk to your client about that too before they do it and make sure that they're going to be in a safe situation if the other party does decide to do anything in retaliation. Okay, so on to step 2. Step 2 involves looking at the contributions of each party. They're the factors that you will find in Section 79 for A to C for the Family Law Act and Section 205ZG in the Family Court Act. Like I said, the sections don't always correspond. So different types of contributions are recognised. You can see them up there. No one type of contribution is necessarily considered more important than another. So significant financial contributions can be offset by non-financial contributions and vice versa. It's not all about who earned the money. When you're looking at the contributions, they're usually looked at in 3 stages. So the initial contributions, what did the parties bring with them when the relationship started? Contributions during, for marriage, that's going to include the period of cohabitation before the actual marriage happened. And post-separation contributions, what happened after it ended. And some more notes on contributions. When you're looking at the financial contributions, it's not a meticulous mathematical exercise. It doesn't come down to dollars and dollars. There's a case of Hain and Hain in 1977 where they specifically say it's not a meticulous mathematical exercise. If a client comes to you and is instructing that they put $50,000 into the mortgage and now they want it back, that's not really how this system works. So it can be helpful to begin managing their expectations early on. Indirect financial contributions can be things like paying the household expenses, which then allowed the other party to put all of their income into the mortgage payments. So that's the indirect ones. Non-financial contributions can include being the money manager, taking care of those sort of accounting duties that some people do, being an artist's muse, which is kind of amusing, and providing nursing services to the partner. Obtaining instructions about the contributions also requires a bit of care. Jacoba mentioned in her webinar last year as well that you need to be quite wary if your client instructs that the other party did nothing, because that's quite rare in reality. Something that I've found in my practice is it's quite common for a client to be convinced by their ex-partner that because that ex-partner had a significantly higher wage and as a result made much more significant financial contributions, that the client is not entitled to any of the assets through a property settlement. They come to you saying that they've been told, they know he earned all the money so they get nothing. So lots of clients don't realise those contributions are also valued, the non-financial and the homemaker type ones. The common one here is the stay-at-home parent, so parenting and homemaker. In regional areas especially, there can also be lots of situations where one party spent a lot of time and effort doing labour on sort of a rural or regional property, like cleaning fire breaks and building fences and sort of stuff that will raise the value of the property. So again, it's really important here to check over the course of the instructions and the advice that your client really does understand the different contributions that can be considered and that they're not selling themselves short, basically, or the other party. Family and domestic violence can be raised in the context of contributions. It's done as a negative contribution kind of argument, which is getting a little bit more complicated here. Basically, that's an argument that a client's homemaking and parenting contributions should be given more weight as a result of having to deal with the other party's behaviour. Jacoba also discussed this in her webinar last year, and what I took from that is that it can be hard to prove to the court, and if you do, it's unlikely to result in a large percentage adjustment. So really for our clients in a really small pool, it's probably worth considering whether the potential gain will be worth the large amount of stress and time that it's going to cost the client. Having said that, I mean, family and domestic violence can obviously be relevant, but I'd say that, yeah, trying to apply it in that way it's going to be quite difficult. So after you consider the contributions of the parties, you reach an idea of the percentage split, and that can be, you know, either in court or in negotiations. Wherever you're at, that sort of helps you reach that initial split. There's no presumption that it's going to be 50-50. It can be 50-50 in some situations. So, you know, if there have been equal contributions, then maybe it's an equal split. So it can be done. It's quite possible, but it's not the starting point. So step 3 is the further adjustment, and that's where you're adjusting the percentage split to allow for the additional needs of the parties. It considers factors which place one party in a position of disadvantage compared to the other one. And I'll note that superannuation is included down there. It's over on the bottom right. As I've been saying, we're going to look at super in more detail later, but for now just make a note of it being in step 3 as well. If parties have entered into a new relationship, the financial circumstances of that aren't usually considered relevant unless they're extremely significant. And so for that, I'm really talking about parties who have maybe married or started a relationship with someone who has a lot of financial resources available. That's not considered to be a very relevant factor here. Step 4 is sort of the last step. It's just the check. It's making sure that the orders are just and equitable, and that in the court setting allows the court to make sort of adjustments where they sort of see that it's necessary. It's going to have a higher weight if it's a small pool, because obviously if there's less to go around, then what's just and equitable might have a bit of a heavier sway over the proportion. So that's the 4 steps. So now if we look at de facto and marriage, the only difference in the 4-step process for de facto and marriage settlements is the treatment of superannuation. De facto couples in Western Australia are not subject to the superannuation splitting laws. That means that in de facto property settlements in WA, superannuation can't be touched. Instead, superannuation in de facto settlements will be treated as a financial resource in step 3, future needs, like we just looked at, which can then mean that the overall split is adjusted in the other party's favour to account for that super amount. Unfortunately, that can mean that where the super is the only substantial asset in the relationship, then there's often no other assets to split to account for that super amount. So the party who doesn't have the super ends up disadvantaged. An example of that could be where the client's been in a de facto relationship with a fly-in, fly-out worker. She had a standard job, she left it to raise the children while her partner kept working because he had the greater earning potential. They've got a house, but there's only $50,000 in it. The partner has $150,000 in super. And after looking at the contributions and the future needs, it looks fair to reach a 50-50 split, or maybe 60-40 in the client's favour. But the reality here is that you can't access the partner's $150,000 super. You can't do that. There's only the $50,000 in the house. So even if the client gets that full $50,000 from the house, she's only then getting 25% of the overall 200,000 that's actually there, and that's because it's de facto. So it can have a pretty significant difference between the de facto and the married couples, and that's why it's really important to be aware of that when you're giving that initial advice, so that you don't give a de facto the impression that they can access that super. Yes, it's relevant. No, they can't get it. For married couples, splitting and flagging orders are available. So for anyone who's not familiar with those, a splitting order will split the superannuation into certain proportions. So, 60-40, 50-50, and it'll